Welcome back. One quick note, someone just asked, did Burr ever go to trial for killing Hamilton? And the answer is no. He was under indictment in the state of New Jersey for murder, and he very wisely just stayed out of New Jersey. So it is possible, I understand. So that was that. And I think now we'll shift our focus away from these grand issues of war and peace and look instead at something else, which is land speculation. And this is a story that begins in what is today Mississippi. Well, actually, it begins in Georgia, but the land is in what is today Mississippi. And back in 1789, a group of land companies had gotten together to buy land along the Yazoo and Mississippi rivers, this land that belonged to the Choctaws. And the investors included Patrick Henry. Most were just speculators. And the whole thing fell apart when they tried to pay in South Carolina and continental scrip, that is the paper money issued by the government of South Carolina and the United States, and the state treasurer refused to receive it, and long story, in 1796, the investors, their lawsuit against the state of Georgia, Moultrie versus Georgia, was dismissed in 1798. The state of Georgia refused to receive this continental scrip. The investors sued, and the case was dismissed under the 11th Amendment to the Constitution, which forbids states from being sued without their consent. Actually, a constitutional amendment pushed by Georgia because it wanted to avoid being sued by these investors from South Carolina and other places who were trying to buy the Yazoo land. Now, this Yazoo land becomes much more valuable in the early 1790s for one reason, and that is in 1793, a guy named Eli Whitney invents a machine that can clean cotton. This land will be great for growing cotton. And the problem with cotton is it is labor intensive to take these bolls of cotton and clean out the seeds and also straighten the fibers. And the state of Georgia actually sponsored a contest. If someone can come up with a less labor-intensive way of cleaning cotton, the state will give that person a great bounty. And Eli Whitney was an imaginative Yankee from Connecticut, and he happens to be down in Georgia on a plantation that belongs to the widow of Nathaniel Greene, the Rhode Islander who had been one of Washington's aides in the Revolution, had led the Southern armies. I believe he still is the most popular New Englander in the South. Georgia gave him a plantation where he retired and ultimately died there. Eli Whitney goes to visit his widow, hears about this contest, and invents this machine, an engine, which is why it's called a cotton gin. You can feed the cotton in, you turn a crank, there is this roller inside with bristles that not only takes the seeds out as the bolls of cotton are passed through, it straightens the fiber so that when the cotton comes out, it's ready to spin. Great thing. And this makes the land stretching between Georgia and the Mississippi River much more valuable. Now, there is a problem with this land if you simply want to go out and start growing cotton, and that is that the Creeks, the Choctaws, the Chickasaws, the Cherokees are living on it. And they don't care how valuable it is to you. They have treaties with the United States which gives them titles to this land. Okay, so that's another story here. What we know is that one day this land is really going to be valuable. One day maybe the title will be claimed, the federal government will extinguish the title of the Indians, and at that point it would be a good thing if we own this land. So, in the winter of 1794, 1795, there is what one observer called a saturnalia of corruption in Augusta, Georgia, the state capital, as representatives of 4 land companies, all based in New England, go down to Georgia and try to get this land. 35 million acres, 54,000 square miles. I know New Englanders have trouble envisioning that much space. To us, Boston Common is probably the biggest expanse of land we ever see. So 54,000 square miles doesn't mean anything to us. I should tell you that Massachusetts is about 8,000 square miles. So we're talking about 7 areas as big as Massachusetts in this territory. And these investors want the state to sell them title to the land, not because they want to go out and start raising cotton. They want to come back to New England and sell this land to other people. And that's really where you make money with land speculation. Not by going out and, digging up the trees and doing all that stuff. You make money in land speculation by turning it over, flipping it, as I guess it would be called. There probably, had there been TV, there would have been a reality show about this whole episode of the Yazoo land speculation. One of the guys who goes down to buy land is the senator from Georgia, Senator James Gunn. And he knows something very important. He has a crucial piece of inside information. The United States Senate is about to ratify a treaty with Spain under which Spain is relinquishing her title to the land along the Yazoo. The Pinckney Treaty of 1795 sets the southern border of Mississippi roughly where the northern border of Florida is. If you can imagine that in your mind and draw it westward, that's the southern border. Previously, Spain had claimed up to the Yazoo River, which is about halfway into Mississippi. Okay? And so he comes down knowing in advance about this. He doesn't tell everyone else in the legislature, hey, you know what? Yeah, because you think, boy, do I really want to invest in this? Well, I don't know. Spain has title to it. Gunn doesn't say, oh, no, they don't. They've made the treaty. Justice James Wilson arrives in Augusta with a satchel filled with bank bills, $25,000 in bank bills. And he uses this money to buy 750,000 acres. Later on, did I mention what happens to Wilson last week? He flees from his creditors, dies in a boarding house in North Carolina. Kind of a sad story. But here he is, hoping to cash in. 3 cents an acre is what he is paying in Georgia. Now, also, they're not simply, who owns the land? Who can make a deal to sell this land? Why are they all in Augusta, Georgia? Because they want the state legislature to pass a law selling them the land. They want the state to enter into a contract. And they're not just there negotiating with the state legislature, testifying before committees saying, it would really be a good thing if you made a deal with these 4 land companies to sell us this land. It would be a great thing. That is one way, I suppose, of getting a legislature to act. Maybe I shouldn't tell you this. There's a more direct way, actually. If you want the legislature to do something for you, you bribe them. And every member of the legislature but one received cash from these guys to sell them the land. And does this ever happen in the legislative bodies you've worked with? He's not aware of it. Good, good. Okay, so the legislature, of course they endorse this. One legislature only takes $600, and later in his re-election campaign it says he shows he's not greedy. Others were getting a lot more. What's in this for me? And these guys, if someone shows up with $25,000 in cash, wanting to pay 3 cents an acre, do the math. How much of that could you get? So the entire legislature, turns out, is bribed. And they sell all of this land to these 4 land companies, and these guys then go back to New England and the Middle States. 3 of the companies open offices in Boston. And the Bostonians are now paying 11 to 14 cents an acre. $2 million are invested in this land in Boston. This is where the phrase, doing a land office business, comes from. An office in Boston selling land in Mississippi, and you're going in to buy the land, not because you now want to go down to Mississippi. Hey, this land is going to be worth a lot more once we get the Chickasaws and the Choctaws out of there. And now that we have the cotton gin, this is going to be worth much more. I pay 11 cents an acre. Next year I can sell it for 25 cents an acre. I'm going to get really rich. Isn't this great? I'm getting excited about this. I'm sorry. Now, in Georgia, it sets off, well, there's a school teacher a 23-year-old school teacher named William Crawford, who thinks there's something really wrong with this whole thing. No, the legislature getting bribed to sell all this land doesn't really belong to them, and they're not doing it because it advances some great noble public purpose. Crawford is an idealist, as some school teachers are, right? And he thinks this is really wrong. Here, it's just a dozen years into independence, and we set off on this course because we wanted to be different from everyone else. And here we have one of our legislatures, getting bribed to sell land to a bunch of speculators who want to get rich. And he starts a petition campaign. He wants the governor to veto the bill. The governor doesn't veto the bill, but people start thinking, well, you know what? It really was wrong. The legislature shouldn't be taking bribes to do this. And I'll tell you, the guy who really gets mad about it is Georgia's other senator, James Jackson. And he resigns from the United States Senate, comes back to Georgia to run for the state legislature because he wants to overturn what he calls the Yazoo land fraud. And he wants to cast out these corrupt legislators who had betrayed the public faith by selling something that didn't belong to them for the purpose of making themselves and some speculators rich. So Jackson runs for the state legislature, as does Crawford. In fact, every member of the legislature was turned out of office in 1795. All of these guys who had accepted bribes, cast out of office. Public indignation against this corruption. It's a lesson, I suppose, to legislators everywhere, that, you do this and you face the consequences, and their consequences are you're out. Not only you're out for being a crook. So Jackson succeeds, having the legislature turned out of office, and then the first thing the legislature does is repeal this land deal. And it's not enough that we simply repeal it. We are embarrassed in the eyes of the world that we did this. This is a betrayal of the faith of the revolution, the faith of the republic. So it's not enough simply to repeal it. We have to expunge this from the record so future generations won't look back and say, what a bunch of crooks there were here in Georgia in 1794. Taking bribes to sell these 54 million square miles. We want to erase that from the record. So they send someone to all of the libraries and any place where there may be the newspapers or the law books that had this on the record, and they cut it out. And then they bring all of these clippings to the state capitol. And they pile this up in front of the state capitol so they can burn it. And former Senator Jackson presides over this ceremony, and he realizes this is too sacred a task to be done simply by striking a flint. We have to set a magnifying glass over it so a ray of light from the sun can start this pile on fire and expunge from the record this misdeed, so that future generations won't look back at us and say, what a bunch of crooks, but will say they kept the faith. It's a great ceremony, the burning of the record in front of the state capitol in Georgia. Has anyone been to Georgia to see if they have a mural commemorating this event? Okay, maybe we should have a class trip. Anyway, Jackson himself holds the magnifying glass over it. So this is great. Now, I'm sure we are all relieved that the Georgians have cleared their consciences in the eyes of future generations. But what happens if you're one of these guys up in Boston and you bought some of this land from the New England Land Company, and then it turns out that person didn't own it because the state rescinded the deal? What do? Is that right? Is that fair to you? I mean, here, you just thought this was an investment. Now it turns out you're part of this whole fraud, even though you had nothing to do with it. You just thought, okay, the Georgia legislature gave them title to this land. I bought it. So is it right that the state does this? I don't mean to pick on you. Actually, the New England Mississippi Company actually gets a legal opinion on this from former Secretary Hamilton. This is in the 1790s. Okay? And Hamilton says the state cannot repeal the land deal. That's a contract. The Constitution forbids a state from rescinding the obligation of or impairing the obligation of a contract. Okay? It's fairly straightforward. The Constitution says it. Hamilton's not making this up. On the other side, Abraham Bishop of New Haven. Does anyone remember that name from last week? He's the guy whose father gets appointed the customs collector in New Haven because the Jefferson administration is... This is in the 1790s, so it's before that. Abraham Bishop argues Georgia didn't have title to the land in the first place. The Indians had title to it. Georgia couldn't sell what it didn't own. And as for the rescinding act that you're so upset about, all it did was nip in the bud a number of aspiring swindlers. Well, who here wants to encourage swindlers? Does anyone? You do, Gregorian. Oh, question. That's a good question. Why don't they give them back their money? Well, why should they? And these people bought the land that didn't really belong to us, and that's, good question. Why don't they give back their money? Sorry.
Where is the money? In the state treasury?
Oh, well, some of it may be. The legislators who are bribed may have some of it. Yeah, but good question. Why didn't they give back their money? Would that have helped anyone? I mean, it wasn't his money. I mean, he paid the money to this guy who opened the land office here. So his issue was you, and you say, oh, that's too bad. The state said I didn't own it to begin with. So should he give back his money to him? Or where will it end? If people start giving back their money, I don't know, this could be why poor Wilson winds up, fleeing from his creditors, because, I don't know. It's a big issue. It's probably the biggest political issue of the late 1790s and early 1800s, particularly in Georgia. Congressman Jackson, he's actually reelected to the Senate ultimately, is adamant about not wanting to have anything to do with this. So if the legislature now is so adamant against Yazoo, they're not going to give anyone their money back. It's a good question. I didn't mean to laugh at it, but I'm sure it was laughed at. But then the serious question becomes, well, what about his money? And where did it go? And shouldn't we get something? This is why it's so contentious. I mean, if everyone can just say, oh, good, they burned it, too bad. I lost $750,000, but it's good. George's conscience is clean. That's one thing. It's such a big issue that when Jefferson becomes president in 1801, he appoints a commission to try to resolve this whole controversy. To give you a sense of how important this was, the commissioners are Secretary of State Madison, Secretary of the Treasury Gallatin, and Attorney General Levi Lincoln. Okay, so it's a pretty important issue. And they suggest a compromise. Okay, Georgia will compensate these investors, these guys who paid. Jackson is now a senator. He'll have nothing to do with any compensation for anyone who tried to profit from this fraud. And in the House of Representatives, John Randolph of Roanoke, who's the Republican leader in Congress, blocks any attempt to compensate investors. They're all against encouraging swindlers, and that's what they see will happen. If someone commits a fraud like this, they know that the federal government's going to bail them out at some point if things go wrong, or if they are discovered in their fraud, which isn't something going wrong, it's something going right. So the moral purists, Jackson and Randolph, block any attempt to do this. William Findley of Pennsylvania, you may recall he had been an anti-federalist. He's now a member of Congress. He speaks up for the investors. I mean, he didn't know anything about the fraud. He just invested in this land. So why shouldn't he be compensated by Georgia? If Georgia wants to clear its conscience, it should pay something for it. So this is the issue. It can't be resolved politically, and so the investors in Boston try a different strategy. One of them, a guy named John Peck, who has title to 15,000 acres along the Yazoo River, sells this to a guy named Fletcher in New Hampshire for $3,000. Really minor amount. I mean, you can do the math and see how much he's paying. Okay? So Fletcher has bought this land. Then it turns out the titles aren't valid. So Fletcher then sues Peck to get his money back, which is exactly what you thought should happen at some point, okay? And in 1809, after making its way through these various courts in New England, it reached the Supreme Court in March of 1809, arguing the case for Mr. Fletcher that he should get his money back because the title was valid. And, Peck says shouldn't get his money back because, okay, it's a confusing, complicated story, and here's where I always lose the thread. Yes? That's a very good question. Did Peck know that the land title wasn't valid? Officially, no. Officially, he thought that the title was valid, okay? He had no way of knowing that it wasn't, even though Georgia had rescinded it. And there's no way he couldn't have known that Georgia had rescinded the title. But he insists that Georgia could not rescind the title, so it must be valid. Also, Fletcher would have had to know. I should just tell you, it's a very important issue. If these two guys knew each other and they were colluding on this as a way of bringing the matter to court, the court would have no choice but to throw it out, because you can't create a lawsuit to prove a point. It actually has to be a legitimate case where two people act in good faith and somehow things go awry. And that's what they're trying to resolve. If it's a case of two guys saying, hey, we think Georgia really screwed up the second time and we want to make sure they don't do it again, the court couldn't hear the case. Okay. So let me see if I can figure this out. Luther Martin is Fletcher's lawyer, and he argues that Fletcher is not entitled, that he is entitled to, I'm getting confused here. Okay. He is entitled to his money back because Peck should have known the title was not valid, okay, because Georgia could rescind the deal. On the other side, John Quincy Adams argues the case for Peck, saying, okay, I got it wrong. See, this always happens with this case. Fairly clear-cut constitutional issue, but then it gets complicated because of these two parties. And in about a minute, I will sort this out. Martin argues for Fletcher. Fletcher had bought the land, okay? Peck had sold the land. Adams argues that Peck does not have to give Fletcher anything because the land title was still valid. Georgia could not rescind it. Fletcher's side, in the case of Luther Martin, argues Georgia can rescind it because a legislature can do what it wants. It is not bound by this, and this isn't really a contract. Is that clear to people? If I say it again, I'm going to mess it up again. So let's just hold with that one. Okay. So the argument really isn't. The argument is: can Georgia rescind a contract? And Martin argues, yes, it can. Adams, and actually later Joseph Story serves as counsel, argues that Georgia cannot. Now, at one point, the court has to adjourn so that for 2 hours, actually, so Chief Justice Marshall can administer the oath of office to President Madison. This is on March 4th of 1809. And it has to adjourn at another time because it has to stop deliberations because Luther Martin is too drunk to continue. Okay. And you think I have trouble remembering which side is which in this case. Now, Story's argument was Peck's title is sound. Georgia cannot rescind a contract. Okay? To overthrow a law because, and the argument is, Georgia overturned the law because the legislature that had enacted it was corrupt. And therefore, the original law wasn't valid because the legislature that passed it was corrupt. They'd all been bribed. What do you make of that argument? The law's no good because the legislature is a bunch of crooks. And they took money for this. Yes?
I think it would depend if they said that there was some sort of compensation. You can't just break the contract to break the contract.
Okay, so yeah, okay, we've got that. That's good. That's that issue. You can't break a contract just to break a contract. But then this other issue is the original law wasn't valid in the first place because the legislators were a bunch of crooks.
There was no argument made that the law wasn't valid because they didn't own the land to sell it in the first place?
That argument had come up, yeah, and so they didn't own it in the first place. They were bribed. They were a bunch of bad guys, and we got them out of there. Okay, so that's that argument for why the law wasn't valid. But meanwhile, this guy's sitting here with all these paper that he bought that's now not worth anything. So how does he get involved in this? And what would you say? Okay, boy, I'm glad that they're not corrupt there anymore. And you say, no, it's a valid contract. You've made a very good point that the state cannot impair the obligation of a contract. This is exactly the point that Joseph Story makes in his argument. The state can't do this. And if you start saying a law isn't valid because the legislature were crooks, well, where do you stop then? Does every member of the legislature have to be a crook? Just one have to be bribed? If you start inquiring into the motives of the legislators, you're never going to end. And you're always going to have a question. So that's basically the argument. To overthrow a law because it was corruptly enacted, Story said, would open a source of litigation which could never be closed. And on the other side, Martin says, yes, a legislature can overturn a contract because a legislature can do things. Now, did you have a question?
When I read the lecture, which was very difficult to read, by the way, because so many arguments.
Yeah.
I thought that one of the arguments they made was that, legislature know better because, the state of Georgia being on the land to begin with.
Yeah.
The Indians did.
Right. Yeah. Yeah. Yeah.
Should have known better.
Yeah, should have known better. Yeah. 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 It's a very complicated case, and yeah, he should have known better, but he didn't. So, okay. Yes.
Are contracts the same as, I know not the same as laws, but it's saying they can't rescind a contract, but clearly legislators
Yeah.
can overturn their own laws.
Oh, sure.
all
Yeah.
the time.
Yeah. They do all the time.
But they just can't overturn business contracts, rescind business contracts.
Well, it says impairing the obligation of contracts. And in this particular case, these guys have a contract which was made under this law. So what happens then when the law is repealed? Does this mean this contract they made under it is also repealed, which is what the court's saying?
Yeah. Going back to what she was saying, the argument was that it was a contract,
Yeah.
but the Indians owned the land.
Yeah, right.
Not you.
Yes.
So,
Yeah.
it was the state of Georgia could not sell, and this guy could not buy
Yeah,
it.
yeah, yeah.
So,
Actually, Gregorian first? Yes? Yes and no. A contract is a specific thing, okay? The legislature passed a law in this case. These guys made a contract under that law to sell the land, okay? So then if the legislature repeals that law, that impairs this contract. So that's where we're getting, I should have said that earlier because that's really at the heart of this. You have all of these contracts made under this law, which then are repealed because the legislature has changed its mind, or it's now become honest, or something else. Okay. Now, actually, fortunately for us, the Chief Justice makes this much more clear in his decision for the court. The court has, two parts to it. One is, it's a case of simple justice. A subsequent buyer, in this case, this gentleman, can't be punished for some original fraud. An innocent purchaser shouldn't be made to suffer for something someone else did. And a concealed defect can't be held up against a later purchaser. Okay, so you've bought something, you didn't know there was a problem with it. Okay, so he sold it to you, concealed the defect. You then sold it to him. He then can't come back and say, well, wait a minute, it's not valid because you are at fault because of something he did. So that's kind of the legal issue here. Now, second, it's actually a more fundamental issue that Marshall gets into. A legislature, it can repeal laws, but it cannot rescind contracts or contracts that previous legislatures entered into. To say that it can is to say that a legislature may, by its own act, divest the vested estate of any man whatever, for reasons which shall by itself be deemed sufficient. Okay? A subsequent legislature can repeal laws a previous one made, and no legislature can limit what a subsequent legislature can do. But if an act be done under a law, a succeeding legislature cannot undo it. The past cannot be recalled by the most absolute power. So here, what Georgia tried to do was undo history and say this never happened. So you can't sell this to him because you never actually bought it. And you're not going to get your money back because you never actually paid anyone for this. We've erased the record. And Marshall is saying a legislature cannot do that. This is, I believe, my favorite line in the whole history of the Supreme Court. The past cannot be recalled by the most absolute power. You know, think of George Orwell's Winston sitting in the Ministry of Truth, changing history to suit present times. And Marshall is saying, you can't do that. The most absolute power cannot do that. So that's the important thing here, that Georgia cannot erase history. And then he did not, and then Georgia had argued as a sovereign entity, it can do this. And Marshall says, no, Georgia is not a sovereign entity. The Constitution restrains it from passing laws to impair obligation of contracts or to invalidate its own contracts. So Georgia is constrained by the Constitution. A sovereign power is not constrained. Georgia is not a sovereign power, which really irritates the Georgians. It's an issue that will come back. So in Congress, in the wake of this in 1809, another attempt to compensate these investors, like this fellow in Boston, John Randolph keeps opposing this. And actually, Randolph is out of Congress in 1814 when Congress does appropriate $5 million to pay off these investors so they'll stop complaining. That is, Congress recognizes that Georgia overstepped by erasing the past. Georgia doesn't want to admit that it overstepped. John Randolph doesn't want to compensate swindlers, but ultimately Congress resolves this. Okay, any questions on this? Torturous case to follow. Fascinating case. There's a good book on it. I believe the Yazoo fraud. Can't remember who wrote it, but anyway. Any other questions on this? Yes.
We know if the people that invested were entitled to the whole amount they invested, 14 cents.
No.
Only 3 cents.
They were compensated, not the full amount. Okay. Yeah. I don't know. I mean, you'd have to look at the record to see how much people got, who were compensated, and so on. Okay? Any other questions on the Yazoo land fraud? Great story. It's one of these great political stories of the period, complicated, torturous, and quite important. Okay. Just seeing. Okay. Now, I mentioned that the embargo was an attempt. By the way, do we want to keep going, or are you folks? I should tell you, the War of 1812 is my favorite war, and if I get started on it, I could be here all night talking about it, and that might be unfair to those of you who have lives. So why don't we call it a night, and when we come back next, you're just, well, I can see everyone else saying, yeah, let's start. Yes. You're like okay, so we'll call it a night. Next week, the War of 1812, in all of its glory, bloody details. We'll reenact naval battles. Okay.